This is the Road Lawyer Podcast.
Good leadership means having the courage to sometimes piss people off. Today we're welcoming William Doran to our podcast. We're continuing our mission to provide useful information to citizens of the world so they can learn about what goes on behind the scenes in the legal industry. William Doran is a family or divorce lawyer with 24 years of experience. He's worked in big firms, small firms, and now he works in our boutique firm, helping people successfully navigate one of the most challenging and often upsetting things that can happen in somebody's life, and that's separating or divorcing from a loved one or previously a loved one. William, thanks for coming today. We're going to talk about a couple of topics, and I thought maybe we'd start off by you giving our listeners, if you can, sorry to put you on the spot, but maybe an overview of, what do you see going on in family law right now? I know people are angry about it in a lot of jurisdictions. We know there's a lot of divorces coming off of the COVID era. Where do you see the state of affairs?
I see it on a number of different fronts. Firstly, I guess systemically, the legal system learned a lot about itself through COVID. I think one aspect of that is coming out of COVID, the technology for doing virtual court and other aspects has really increased. And it's a technology I wonder if we would have today if it wasn't for the pandemic. It sort of forced the legal system into situations where if there was going to be any access to justice, then people would have to participate virtually. Some of those components of virtual court have been maintained, even now that the pandemic is hopefully gone its way forever. And then there is also a return to in-person court as well. But a lot of the administrative aspects of, scheduling dates and doing things like that, even shorter motions are continue to be virtual in most jurisdictions. And it is noteworthy, too, that every jurisdiction seems to have its own ability to tailor the services to their populations. So, for example, in Sarnia, case conferences and settlement conferences continue to be virtual, whereas in London, those conferences are now back to being in person and have been that way since April of 2022. So systemically, on the one hand, it's been nice in the sense that some of that technology, I believe, is going to be maintained, which also to some extent goes to access to justice. There are people in rural settings and people just without resources that can't necessarily travel even to the courthouse and be a part of a process like that. So there is discussion even now as to in what circumstances will we extend virtual court to people perhaps that can't get there due to disability, handicap, financial means, things like that. So that is something that continues to evolve. But
and let me jump in on that one, because I think that's an important, and it's hard to get consensus amongst the legal community to advocate for it, because what I see is, excuse me, there are kind of the old school that like things being done the way they were done before, right? The protocol, the transition, tradition, and I can understand that. But the result is, I think, hundreds of thousands of wasted legal hours of lawyers kind of sitting around waiting their turn. And when you're talking access to justice and people are paying hourly rates that are quite high in this field, the clients are paying thousands of dollars extra because of the legal industry's refusal to modernize as quickly as possible. Do you see that, or is that true?
Yeah, that's a component for sure. I know myself, especially on days where we're just speaking to a matter to schedule a next step or something like that. If I have to get in my car and drive down to the London courthouse and sit in a packed courtroom for 2 or 3 hours until my matter gets reached, that's a added cost to the client for sure, right? There's time spent on such a thing.
And that's where I want to say clearly and call out the legal system, because I know that some judges still like having people sitting there, standing up. I know that that's a tradition that's liked. But if you're sitting or any lawyer is sitting in court for 3 hours waiting, there is a human being paying for that. And I think that that hasn't been articulated strongly enough to these kind of accomplished, powerful people who like things the way they were, in terms of how many extra millions of dollars are being spent that aren't really the most effective use of your time. And I can see from watching your practice, you're able to do a lot more in different jurisdictions, which allows you to help people who want you, where in the past they couldn't get you because you were always tied up in court.
Yeah. And just another thought in that regard. Um, when I have been speaking to matters virtually to schedule something, I'm sitting in my office. If I'm number 60 on that list, I could click on a button and mute my
Hmm.
mic and shut off my video, and I can actually work on a number of other things
Yeah.
while I'm sitting in my office. And
Mhm.
then when my matter gets called, then I can follow the list, and every now and then I turn my mic on to hear where they're at. But yeah, it's a much more useful and productive use of time, um, all way round. And I haven't really heard judges speaking so much about having that more the more I don't know, bureaucratic scheduling of things to be for that to be taken away virtually anytime soon, which is comforting to hear. I think that's very productive. I think in settlement conferences where people are required to focus their energy on trying to settle their case, uh, sometimes it's very helpful to be face to face with the judge and with the other party and the other lawyer. And judges use those opportunities to, force people into the hallway and get them to start negotiating. It just seems that in-person aspect of that part of the process is very helpful. And I've had cases recently where I asked myself, if this was virtual, would this case have settled? And the answer probably was no, it wouldn't have. But being there in person for that aspect was very good. But these other um,
Mm.
aspects that don't necessarily involve the client, even a lot of motions that are procedural in nature, the
Mhm.
clients don't need to attend, don't need to be there. They can if they want to be there. Those things, that aspect of court continues to be virtual in most settings, but I could see shortly that going back to being an in-person thing. And that also has the same thing as what we just
Mhm.
discussed about sitting in court on a motions list that might have 20 other matters up on the day. And then, you're waiting it out at the courthouse as opposed to maybe being back in your office, able to do other things and ultimately, clicking on your mic and
Yeah.
video when your case is called.
That's a great point about getting settlement because you're in person. Something changes when you're face to face with people and allows. That's one thing I found on the Zoom, which I really do really do support as much virtual as possible. But you really don't get people paying the same attention. They're looking at the screen, but you don't know if they're watching YouTube videos as they're looking at the screen or if they're paying attention. So you don't have that tactile. We're going to talk about two topics today. I think that are of interest to our viewers. One, we're going to talk about a trial you had recently in which you got an amazing result, and I think it's important for people to learn about what happens at trials in family and divorce settlement situations. And then lastly, and I know we'll keep what's probably the most controversial to the end, but I think you've done some pioneering work on access to children, access issues, and the vaccines and vaccine mandates, and what's happened to some fathers who didn't get vaccinated and how it affected their access to the children. But first of all, I wanted to give you an opportunity to talk about this recent trial you did on short notice and describe a little bit about what happened and how you were able to get such a good result.
Yeah, the case you're talking about is known as Moffat versus Moffat. It's now a release decision of from Mr. Justice Mitro. It was heard the week of October 24th for 5 days, and then it concluded on the Friday of that week, starting on the Monday. It was very interesting because my client, who's is an elderly person, she was just shy of 80, I think, at the time of trial, had come to me in the summertime, and she was without a lawyer. When I say the summer, like mid to late August. And at that point in time, when she told me that she thought the matter was on the verge of trial, my initial inclination was, well, I can't really help you with that because that's a lot of work to try to figure out in a short period of time. And it's some it could be something analogous to writing an essay. It's like if somebody writes the whole essay and they get to the conclusion and then passes it to somebody else saying, "Here, you write the conclusion now." It's
Mhm.
like, I don't really want to do that because I wasn't really part of the whole project, kind of thing.
I almost think it might be more akin to if somebody was working on their thesis or their dissertation and they wrote it all and they said, okay, now you go and present the thesis in front of a panel that's intent on attacking you. Like you want to have the groundwork done. This case is special to us because this older lady was quite sweet. And I don't know many lawyers who would take somebody's case on the eve of trial. Well, what kind of convinced you to take a risk here?
Yeah, so I think, in light of what I just said, I think it was her vulnerability that struck me. I thought, this woman, she had a lawyer for a period of time, um, right at the trial management conference stage, which is just literally the last conference before you have before the matter is set down for trial. It was at that conference that she attended on her own, and then shortly thereafter, a motion was brought against her for lack of financial production and disclosure, and she was really floundering and didn't know really how to put that together. And so I think when I met with her, it was just the state that she was in, and I knew that if I didn't help her, likely nobody else would.
And let me put that a little bit into layman's terms for people who aren't familiar with the court system. This matter had been ongoing for a long period of time. It was just about to go to trial, and William is too much of a gentleman to speak any ill of anybody. But the lawyer got off the record, leaving her without counsel prior to trial. And then all of a sudden, this layperson, 80-year-old, gets a motion for contempt because she's not producing documents that she really doesn't have any idea of what the obligations are. And so she kind of came to us and to you specifically as her last straw or whatever there is. And so how are you able to take a long proceeding and then step into trial?
It was really helpful that she was, well, really not understanding as a layperson what to do to, position herself to be ready for trial. She was very organized with her documents.
Hmm.
She had several boxes and stuff. And when I asked about something, she was very organized in a way that she says, "Oh, I can find that for you." Or if she
Hmm.
couldn't find it at the moment, she could, sometime shortly thereafter. So that was very helpful. And I think sometimes the difficulty is when someone comes to you at the 11th hour is under you want to make sure you can understand their case and that what you're going to do is actually going to help. I took several weeks to review her case, the documents that she had provided, conversations that I had with her, and even a phone call to the opposing counsel to say, "Hey, you know, what's this case about? Where are we at?" Kind of thing, right? I was very fortunate. Norm Pizzali was the lawyer that represented the husband in this case, and he was very cooperative in talking to me about the case and what the issues were and how long he saw the trial being and things like that. There's a lot of lawyers that are very good that way,
Hmm.
and there's some certainly that probably wouldn't have given you the time of day. Like, good luck with that. But that was helpful for me, and that allowed me to frame the issues. And then after some meetings with her, saying, okay, I think I can do this. Um, Certainly, we're going to be missing aspects of the case that I would have done differently than your former lawyer, right? I might have proceeded differently by bringing motions at certain stages. I might have pleaded the whole case differently as well. But when you get the case, a couple of weeks before trial, it's not really you're not really in that spot to start to amend pleadings and do things like that. So you work with what you got, and you do what you can do for the client. And on the other side of it, when you get your result, which we have now, you can see the case, I think, more holistically as to what was properly pleaded in the beginning, what could have been
Hmm.
pleaded differently, And then that goes to further advising the client as to what to do with the result that she did get from the court. So in our particular case, how it was a bit different is that there were certain aspects of the case that it could have been pleaded. And of course, when I say pleaded, these are claims you're making before the court. She could have made some additional claims in this proceeding that started in 2019 that would have opened up much more opportunity for financial reward.
Hmm.
And some of those things just were not pleaded. It's very complicated set of circumstances where there was two very senior lawyers that go back. This goes back to like 1998 through to 2003, and two very senior lawyers at that time were involved in the negotiation of a separation agreement with these parties. And my client's ex-husband was a lawyer for a period of time, even, right? So he had
Mm.
sort of some, let's say, knowledge as to process that maybe she didn't have at the time. But nonetheless, that was supplemented by really good counsel on her part and for him as well. But that, even after coming up with the separation agreement, they still ended up in court in 2003, 2004. And a very odd situation happened where they, on a motion, they resolved some issues, but it was all on an interim basis. And then nothing happened for 16 years almost.
Hmm.
And it was at that time that the husband had decided he was coming up 80 as well. He wanted to terminate spousal support, and that was what the issue was at trial: is should he terminate spousal support, and what was the retroactive implications of it as well.
Mm.
So at trial, we were able to get an award for her for some retroactivity on some of the issues that she was pleased with. But there were other things I think that if they had been pleaded, could have opened up, uh,
Hmm.
other aspects. Having said that, it was even at trial. Mr. Justice Mitro, myself, and even Mr. Pizzali at one point all seemed to share the idea that the case was complicated in that sense, and
Hmm.
that even though we had these senior lawyers from yesteryear prepare the separation agreement, and were part of this core process, sometimes just with the change of law and passage of time, things do get more complicated, and that I see that as being one factor in the case.
For you to take it on at such short notice, and I think you're kind of avoiding talking about the great results you got, and I appreciate your humility. So we won't have to focus on that. But what I can tell the listeners is that William took this case on at the last minute, and everybody in the office knew he was all in on this case and helping the lady, and he got a fantastic result in the circumstances. And would you do it again? Would you take on a case like this again at on the doorsteps of trial?
I think I would in certain circumstances. I have had people in the past approach me again at the 11th hour, and I've declined those cases. They don't It doesn't happen a whole lot. Usually, people don't get to the door of
Hmm.
trial without a lawyer. But in this particular set of circumstances, due to her, her vulnerability, her age, um, and her just continuing to maintain, she goes, well, I got something here. Like, I think there's something that no one
Hmm.
has seen, and I think you need to take a look at it. And I'm glad I did in the end, because I think I did see something that had been overlooked, and I think that was the basis for the award that she did get. And you know,
Hmm.
you know,
If
the,
something seems unfair objectively, with good counsel, you can generally rectify that. It's just sometimes it's hard. People will sometimes only give you their perspective, leave out all these details, and so you can take on a fight. And that's why I appreciate that you took a while to make that decision, right? It's not just that emotional, because this is a fault of mine sometimes. Somebody will come in and tell me a story that seems tremendously unfair, and I'll be like, I'm your guy. Let's get high. And then you've kind of realized later that there has been some selective delivery of facts that all of a sudden now I'm committed to something that it's not what I thought it was, or it wasn't as much of an injustice. It's something that I'm seeing, and I don't know if you'll comment on it, but I'm finding more and more that too many people counsel are used to things settling. And so they'll do the work, but then when it comes to, and this, we're not talking specifically in this case, but what I'm finding is more and more lawyers are getting off the record at the 11th hour. We're seeing it in personal injury. It's happened in some litigation files and in some family courts. And I wonder if, because there's been such an increase in settlement that some people take for granted that it's going to settle, and they don't, and the actual workload to do a trial is intimidating. And if you haven't really prepared for that trial, you don't want to, you find a reason to get off the record, and then the client's like sitting there. Do you see that at all happen?
The lawyer really has to ask themselves right at the get go when you first meet with a client, whatever stage it might be at, I suppose, is you got to be prepared to take it to trial.
Mhm.
I think if you're a lawyer and you're looking at yourself, you've been practicing 10 or 15 years and you've never taken anything to trial, I think at some point you maybe owe your client that disclosure to say, hey, listen, I'm not really a trial lawyer, but I do see this case as largely settling. But if the
Mm.
case had to go to trial, I would not be the one to do that. You would be better served with having somebody with more experience. And I think that that might be something that you're referring to, in the sense that there are lawyers that have practices that every single case is settled, right? And that, on the one hand, sounds great. We're settling cases and has this nice sort of ring to it. On the other hand, I wonder sometimes if you're because you're uncomfortable with, let's say, taking a matter to a trial, you're not familiar with it, you don't have the experience doing it, you do your client a disservice by not being able to take it to trial, not having the skill
Mm.
set and the experience to do that. And if the matter needs to go to trial, it needs to go to trial. When I first looked at this case, what I was really looking for was, did she have a strong position on everything? And I think often lawyers get caught up in the narrative of the other party's case. They
Mhm.
read the pleadings, they are looking at um, the case law that the other lawyer might be advancing, and not really focusing on the narrative of their own client's case. That narrative, uh, perhaps having you know facts that really bolster certain issues that give them a strong position on things that maybe others have overlooked. And I think when I meet with somebody for the first time, I am prepared to take their matter to trial if it needs to go that route. Having said that, certainly negotiation towards settlement, whether in court or even just negotiating a separation agreement, not needing court, is the way to go, provided that you're not
Mm.
compromising and caving to the extent of, undermining your future. And
Yeah,
I
your
think,
strategy is powerful because if, and I don't, the trial lawyers that have been mentors to me and the ones that are most successful, they echo that from the day they take the file, they're preparing for trial. And what that does is increase your settlement position, because if the other side knows that you have the parts to go to trial, you'll get a more favorable settlement. And what's, I think, one of the clips that we need to get out there to more people is to have, when you're shopping for a lawyer, ask a lawyer hard questions, right? And I don't think often enough clients ask lawyers hard questions, but the question that you raise there is, can you tell me the last time you've taken a matter to trial and received a verdict or a judgment, right? Because people can operate under trial lawyer labels, but there's partners now who have never done a trial. And I think if you're going to call yourself a trial lawyer, at some point you have to have the courage to take it to trial and risk being attacked by a judge, risk blowing a cross examination. It is a totally different world than paper pushing files. So I hope people take from this conversation that if you're hiring a lawyer and they put themselves out as a trial lawyer, you ask them, when is the last trial you did? Can you send me the citation to read that trial? You cited that trial you just did. People can read it and learn about what you did and see the favorable comments you got. That's spectacular. I think too often they see a big firm and they think, oh, must be trial lawyers, and not everybody is. It doesn't. And if we're talking to, if any, I know we have a lot of lawyers who listen to this. Your other point that I thought was really strong is to have the confidence in your case. Too often, I find that young people hear a more senior lawyer advocate a position, and they're intimidated by it, or they start to question themselves, and it's that courage needed to advocate for your client. What do you say to young lawyers who are in that position?
When the day comes where you're starting to tell your clients, well, I'm going to put my best foot forward for you and we'll see what happens.
Hmm.
That's not what they're paying for.
Hmm.
They don't want to see what happens. They want to have an idea of what will happen in their case, a real diagnosis, prognosis of what's going to happen, and being able to assertively, look people in the eye and tell them the good and the bad and the ugly.
Hmm.
It's just
Hmm.
part of life. Most people have strength in some of the issues and some weakness in some other issues, and it's not an all-in thing. But I think to be straight up with people and to tell them that they have to expect certain aspects of their case to perhaps go one way as opposed to a way they would like it to go. Basically, a reality check. And I think from that, I'd rather say to people, listen, I'd rather be straight with you and tell you you don't have much of a case and push your retainer back across the table than to take your money saying, I'm going to put my best foot forward for you, only to spend your money and have you lose your case and go, wow, look, why did that guy not tell me straight up from the beginning, right? I
Hmm.
mean, it goes to integrity and being able to not just have the courage to take the matter forward for your client, but having the decency and resolve to tell your client the strength and weaknesses of their case out of the gate.
That's definitely, I think, part of the philosophy of the family department you run is if there are triable issues, you will do the work to be successful. But our goal also is to not increase legal fees unnecessarily. And I think that's kind of what you're saying in a kinder way, in that sometimes these things can keep fighting because one or both lawyers won't tell their clients that they're being unreasonable because their unreasonableness results in more legal fees. And I think a lot of people respect that about you. And I know that this particular client, thanks God that you decided to take that case and to do such a good job for her. And one of the lessons I think I would share with people um, is that bravado doesn't always mean competence, and doing the hard work. And being humble, you can go into trial and get tremendous results by doing the work, being polite. You don't have to treat other people crappy, and that's a reputation that I think follows you wherever you go. I wanted to move on now. I know a lot of listeners out there are very interested in how COVID and vaccine policies affected access to kids, and I know there are some tragic cases out there, and you've certainly been in the trenches fighting for some dads. Do you want to tell us a little bit about how COVID and vaccines affected access to kids?
Certainly, it seems that depending on what date you stand in over the last 2 or 3 years, that seems to dictate as to what the courts will do in a certain set of circumstances. The law has evolved incredibly from the start date of the pandemic until now. Initially, when the pandemic first started in March of 2020, the issue at that time was parents that had visitation. And so they had a court order, they had a separation agreement that dictated, every other weekend, every Monday, Wednesday, or whatever. And immediately, due to the pandemic and the shutdowns, a lot of fathers and mothers were cut off of their visitation time with their kids, all in the name of safety and the best interests of the children, of course. And so those were the first sort of set of cases that started at that point. As time evolved, in my view, the judiciary got those cases correct and saying, listen, there's the best interest of a child, but we can take safety measures. Clearly, if a child is sick or there's a parent that's sick, maybe a visitation could be rescheduled. But the best interests of the children seem to be put, as far as their relationship with a father or a parent. Um, that relationship seem to supersede making the child a little bit more safe by denying their visitation. In other words, the relationship between the father and the son or daughter, or mother, son, or daughter, was higher up the best interest
Yeah.
threshold than saying, well, let's keep kids safe. Then the law sort of evolved to the point where then you had the vaccination coming on the scene. And nobody know what that meant. And
So let's just give a little context here.
yeah,
Beginning of COVID, uh, around March, we start shutdowns, right? And then I think what we saw in family proceedings, divorce proceedings, is some people will act in bad faith. And so, I know we saw some parents say, oh, my spouse can't see the kid because my spouse is not following proper procedures. They're going out, they're not following the 5-person thing. And so you could kind of make these allegations and vilify people, somehow suggesting that that behavior would endanger the child, right? Like being a violent person, like taking them out to bars or something, right? And initially we can understand because we didn't know what we didn't know at the point. The courts were somewhat open to those irresponsible acts, although I think we've seen people get access who are drug addicts and keep access, but in this in this pandemic, some people who didn't follow the rules got hammered. To me, it looked like once COVID restrictions got in full force, the courts were very intent on enforcing compliance with regulations to the detriment of children's relationships with their parents. And what I would say to young lawyers, when something seems unfair, just because a judge doesn't agree with you, it doesn't mean your fight is not the right fight. And this is not specifically what you're talking about, but I know we had a case where there was a father who had custody of a 2.5-year-old and who lost it. Could you tell us a little bit about that,
yeah.
if
So,
you're able to?
yes. So again, I think in the early part of the COVID cases, you have to remember too that it was pretty common that the pandemic, COVID, didn't affect children the same as it affected adults, and especially more vulnerable adults, like people that had pre-existing conditions or they were elderly. However, as the pandemic went along, that changed for children. And then when vaccination presented itself, then parents then had to grapple with the idea of, well, children are less likely to get really sick, but we don't really know a lot about the vaccination either, right? It's new, it's
Mm,
on the scene. It's different than in the past, like when vaccinations have gone through a lot of rigorous testing over time. This time it was like it was clear we needed something quick. And so a lot of parents had skepticism as to whether maybe they were almost doing more damage than good by vaccinating their child with a vaccination that had not yet been properly tested and vetted over a period of a number of years,
mm,
unlike vaccinations previously. So those cases really came at an impasse between parents that obviously were separated. One parent wanted to vaccinate their child, believing in the government proclamation that that's how things should go. And then the other parent would say, well, no, I think we should be more cautious because well, our children are less likely to get really sick. So why would we put a vaccination and a fairly new technology in the
mhm,
vaccination um, when we don't really know about symptomology and things like that that might come out down the road. So the second leg of cases seem to be about that and about the decisions of parents as to whether they can vaccinate their children or not. And as these cases came before the courts, parents were saying, okay, we can't agree on vaccinating our children, so we're asking the court to step in and do it instead. And then there's another aspect of it that is parents that have made the choice not to get vaccinated. And what would the courts do with that? And so one parent's in there saying the father won't get vaccinated, therefore he's a risk to the children, and his visitation should be restricted. And that's where the case law became very inconsistent from my perspective, in the sense that some judges were um, not giving a lot of credence to that, again, holding to this idea that children are less likely to get really sick. So why would we curtail a parent's visitation schedule because of a very nominal risk to the child.
In some
How
cases, the parent had had COVID and just wouldn't get vaccinated. It even went that far.
Yeah. So in my experience two specific cases that I have had, one case was where a father had been on a paternity leave with a young child. The
Hmm.
child, I believe, is just coming up. Just he just had his one first birthday and was in his second year, and then he had two other children that were under 6 at the time. So he worked from home too. Even prior to the pandemic, he worked from home. So
Mm.
this is a guy that was in the game of parenting his three young children, and mom also parented them as well. And then when the pandemic came on the scene, the mother brought this issue before the court and asked the court to restrict his visitation. And on an interim motion, the court did that.
And so he had full custody at that point.
No,
Uh,
they were living separate and apart in the same home, which
okay.
happens sometimes when people
Yeah.
separate. They don't necessarily physically separate, so they were separate and apart under the same roof, so to speak. And through that period, he had been on this paternity leave for 3 months with his
Hmm.
youngest son. So he was there every day with the kids. Mom had gone back to her employment, and it was at that point in time that a judge restricted him. He went from having the kids in his home all the time to having mom move out to live with her mother, and having his children every other weekend during the day and a day or two through the week, on a very limited schedule with no overnights.
And he had to wear a mask too, was another deal.
He didn't have to wear a mask um, in the house with the children, but he had to follow all government protocols in the community, which he was always prepared to do. He even said,
Mm.
before the decision was made, that he would follow government protocols. But in addition to that, a judge, when he did have his children with him, restricted him from being in the matrimonial home or outside. He couldn't go to a mall with his children, couldn't take him out, for ice cream somewhere indoors, couldn't visit his mother, their paternal grandmother, in her house.
So he had a 1-year-old, and because he wasn't vaccinated, he couldn't take his kids out in
He could
to the.
not be with his kids. He had to have his parenting time in the matrimonial home, inside or outside. He
Mm.
couldn't be in the mall or at another person's house. He was restricted that way.
And the courts took away his ability to have his kids overnight.
Yes, in that particular motion. So we ended up appealing that motion to the divisional court. The divisional court, right at the end of the hearing before the panel of three judges, this was back last October 2022. At that time, the court immediately said, listen, we find at least one mistake that the trial judge had made on the motion, that is, and that is that he put all these restrictions on the father for the visitation and stuff like that. So they immediately wiped out that he couldn't go to the mall, he couldn't go to indoors, he couldn't, it took all that away immediately. And then they've reserved their decision on whether his wife or him, his ex-wife or him, could make the decisions as far as vaccinating the children, because the motions judge also decided that the mother would be put in that position to vaccinate the children. And then his schedule is yet to be determined as well, as far as how that might open up over time. So these things are all still in flux, and but a very interesting evolution in the vaccination case occurred recently when the Ontario Court of Appeal overturned a decision of a judge known as Justice Pazarat, and he basically had the opposite result of the case I'm referring to. He put mom in the driver's seat as far as decision making for vaccinating the children, and mom had made it known that she was against vaccination. And in that case, the kids, I believe, were 10 and 12, and both kids have expressed wishes that they didn't want to be vaccinated. So he basically, Justice Pazarat, made a decision that mom could be the one to decide to vaccinate the children or not. So that was appealed to the Ontario Court of Appeal, and they set aside that decision and gave the father decision-making rights because he was more in line with government protocols,
But
which
there was no policy that said kids had to get vaccinated.
no, it's never that the court is ordering anyone to get vaccinated. They're ordering which parent can make the decision. And
Mm,
so that is what they're doing. The parent then would still have to take the child to a
mm,
doctor. And if a 12-year-old sitting there with their doctor saying, I don't want to be vaccinated, they're not going to be forced to get vaccinated, right?
mhm,
But the courts are in the business of making an order, allowing one parent over the other to vaccinate a child. So that decision just came out in February from the Ontario Court of Appeal overturning the former decision. But what's interesting is since then, Ontario Superior Court decision
mhm,
so the court below has distinguished that case and has said pretty much if we give criminals the right to a full trial,
mhm,
their access to justice, why would we not be giving children the same right that a parent could actually take their matter to trial where they could properly have their, you know,
mm.
experts,
Yeah.
often thrown aside as internet experts or
Mm,
conspiracy theorists, but then they would have their right to call these people at trial, get their evidence in, they could be cross-examined, and it would be a full case. And so this Ontario Superior Court decision distinguishes itself from the Ontario Court of Appeal decision and said, you know, this matter should go to a trial. And I would say that how can you make a temporary order to vaccinate children when you can't undo it once it's done?
yeah.
So the moment in my first case that I was referring to where the court allowed the mom to vaccinate the children, she went out the very next day, or within a few days, I believe, and vaccinated the 6-year-old. And at that time, I believe children under 5 could not yet be vaccinated. It was not yet it hadn't crossed that threshold yet. They can now.
Mm,
But it was very interesting that they, the court did that in that case. Another court in February 2022 made pretty much the opposite decision. So, thus, I think that's why the appeal courts have been receiving these motions because when the public interest is at stake in the sense that people don't know what the law is,
mhm,
the court has to step in and make it clear. The Ontario Court of Appeal uh, had the opportunity, I think, to do a lot more and just chose to deal with the issues that were before the court, which is proper. But this lower court decision is very interesting because when I was arguing a different vaccination case just a few weeks back, the judge at that point asked about this case, and it just been released like the week before. It's a very lengthy decision, and it stands for these matters probably shouldn't be determined on a motion. They should be
mhm,
determined at trial, which would allow uh, a father or a mother who wanted to test the government's position on
mm,
vaccination. They could do it. They could call witnesses. They could, take that position on. Whereas at these interim motions that are done by way of affidavit, up until this point, they're just pushed aside. It's like, well, no, it's affidavit evidence, and you can't attach that internet report that you got. Yet a judge can take judicial notice of the government proclamation on the website,
mm,
and that has been the real, I would say, what has been unfair, uneven playing field so far is that if you're for vaccination, you just you hang your hat on the hook the government's given you on the website.
mhm.
But if you're against it, there's no hook.
No.
you the way you're going to challenge that position and introduce evidence is by way of having an expert come testify, and then obviously the other party can cross-examine them.
I'm not saying it's in any of your cases, but what I've seen in the legal system is like an absolute reluctance to allow experts into some of these contentious vaccination cases. My reference are the military guys who were kicked out for not getting it, and the whole scheme of how they did it was to deny them the ability to have a trial. And I think that's why trial lawyers, that is a service that they provide to society, is that it's not just kind of where the political wins are. It allows you the ability to call experts to build a case. It takes a while and it changes the decision making. And I think you're certainly a leader in standing up and because I know for you, you're not political. You're just dealing with people who are coming to you and saying, "Hey, I feel strongly about this, uh, and I want to fight for my rights." And you certainly stood up to some to strong opposing winds in some cases. And I know that wasn't hard. Like every one of us is terrified of being labeled this or that for daring to make an argument. And I think when we look back on these 2 years, I hope we end up doing a study and looking at how life-changing decisions were made really without all of the facts, but with an element of certainty that hurt people. Um, are you still seeing some of these vaccine issues come up, or has it kind of blown over now for access to kids?
Decision from the divisional court is still outstanding, so we're waiting to hear what they will say in regards to the decision made by Justice Tobin on his interim motion back March 2022. So that's key, and I think when that comes, I believe they will comment on the issue of whether this type of thing can be heard on an interim motion or should it go to a trial, as this other judge has recently decided.
Well, William, I know you're busy because there's a lot of people getting separated after COVID and after Christmas, and you're in high demand. And I want to thank you because I know you're humble in your nature, and it's difficult to talk about contentious cases, but I think people need to hear about what's going on there and see different perspectives. I think it helps them make better decisions when they hire lawyers for divorce or separation. And I think everybody who listens to you can see how much you care about doing the right thing, and you certainly put your clients first. And I just want to do a shout out because it there's a lot of demand right now for family and divorce lawyers, and it could be easy only to take kind of the easy slam dunk cases. And I think it's a little cowardly, and I'll say this, 'cause I'll probably be trolled, cowardly to only take slam dunk cases. Like you become a lawyer to change people's lives. And sometimes that means that it's a tough case. It matters. The law is not settled. Somebody has to stand up for this person who's claiming an injustice. And if you're only taking slam dunks, you're just billing and settling. And you have certainly over the last 2 years really shown that you're prepared to stand up for your client's interests and do it in a courteous and humble way. And the results you're getting are are a representation of that. So thank you for taking the time to chat about some difficult conversations and helping people understand the system.
And thank you, and I appreciate your kind comments.
Cheers.
This is the Road Warrior Podcast.
Good leadership means having the courage to sometimes piss people off.